How do you settle your personal injury case without a lawyer? I'm attorney Ali Awad, the CEO lawyer, and today I want to cover a topic that most lawyers are never going to touch. You see, here's the thing. Not every case requires a lawyer. So if you're involved in an accident, sometimes you can settle your case without having to hire a lawyer, without having to pick up the phone, without having to sign any contract, and I'm going to teach you how to do that today. There are three things that you need to keep in mind throughout this video. Number one is case value, number two is negotiation, and number three is your medical bills. First, how do you know what your case value is and what the right number to settle for? Every personal injury case is valued under four main categories. Number one, your medical bills. Number two, your pain and suffering or general damages. Number three is your lost wages or lost income. And finally, number four, your future expenses and damages. So first, let's start with the medical bills. It might seem like common sense that your case is worth at least what your medical bills are. But what a lot of people make the mistake of is that higher medical bills means less money in your pocket. And that is absolutely wrong. In many cases, the higher the medical bills, the more money that you get to keep in your pocket when the case settles. Now, why is that? Because insurance companies can only determine the value of your case based on what your medical records show. So if you're looking at your medical records and you see x-rays, MRIs, chiropractic, orthopedic doctor, physical therapy, injections, you know that this is extensive medical treatment, and that means that your pain and suffering will likely be just as high. So number one, you have to make sure that your medical bill's covered and that the totality of your treatment is covered before you begin your negotiations. Number two is pain and suffering. Most insurance companies value your pain and suffering based off of your medical bills. Many lawyers will use a rule of thumb like 3 times your medical bills or 5 times your medical bills to determine how much your pain and suffering really is. But what happens if you're a pregnant woman, for instance? You get in a car accident and you can't go to the emergency room to get MRIs and CT scans because it's not safe for your baby. But you still get hit by a drunk driver who was not paying attention, and there's a huge insurance policy to go after. Does that mean that your pain and suffering is directly tied to your medical bills? No. This is why it's so important to have proper documentation and even narratives from you, the injured person, or your primary care physician that shows what you went through as a result of the accident. It's not always cut and dry. You need to make sure that you have the proper documentation. Number three, lost wages. Many of us are business owners, entrepreneurs, or even Uber drivers and Lyft drivers. When you get paid as a 1099 independent contractor or as a business owner, it's really hard to calculate your lost wages. Now, if you're a W-2 employee, it's very simple. You just get a letter from your employer and they will state exactly how much time and how much money you missed as a result of this accident. But if you are a business owner, here's what you need to do. Number one, make sure that you have proper tax records for your income. But if you just started business this year, then you can use invoices from prospective clients that you are intending to do business with. On top of that, number three, you can sign a sworn statement or an affidavit that says exactly how much money you believe you lost as a result of this accident. It's very hard to calculate numbers when you're a business owner, especially if you're just getting started, but these are three ways that you can make sure that you get covered for your lost wages. And finally, number four, how do you calculate your future pain and suffering if you have no idea what you're going to need in the future? You see, not all of us have a crystal ball, but what you can do is go to an orthopedic doctor or some specialist that will calculate the likelihood of you needing future procedures or potentially surgeries. You take that estimate and you include it in your demand to the insurance company. That's why it's so important to go to the right doctors, because you can get paid for damages that you haven't even gotten yet. Remember, when it comes to medical bills, pain and suffering, general damages and lost wages, or future damages, proper documentation is key. But you can do all of this on your own if you are diligent and you make sure you do your research by finding the right doctors to treat you for your case. The second issue is negotiations. How do you negotiate properly with an insurance company? Well, here's the rule. Never accept the first offer from an insurance company.
We are prepared to make you a very generous offer.
And we are prepared to reject that offer.
Michael, you haven't even heard.
Never accept their first offer. What is your second offer?
Most insurance companies have a negotiation strategy where they go 3 to 6 counter offers before they give you their top offer. In my opinion, after handling thousands of personal injury cases and collecting tens of millions of dollars for my clients, I will tell you that if you have to start with a number to the insurance company, make sure it's a very high number. In many states, like Georgia, you can send what's called an OCGA 33328 letter. Under this statute, the insurance company must disclose exactly how much insurance coverage is available. For example, if you get rear-ended and the accident is not your fault, you can contact the other person's insurance company, send them this letter, and require them to tell you how much insurance coverage is available. If it's $25,000, $50,000, $100,000, then that's the number that you want to start with. Now, there are other tricks that you can use for negotiations. One of my favorite strategies for negotiations is to not give a number to the insurance company or to the opposing party and let them negotiate against themselves. Here's one way that I do that. When I'm on the phone with an insurance company or I receive a letter with the first offer, I evaluate the first offer and then I ask the insurance company this question. Have you taken into consideration all of the damages that my client has suffered as a result of this incident? What that does is that puts the insurance company on their toes and it allows you to open up the doors for the rest of the damages. Specifically, you ask them, have you covered all of the medical bills? Have you allocated money for pain and suffering? Have you considered the lost wages? Are you giving me, the injured person, any additional money for my future damages? Now, the insurance company will always tell you, yeah, we considered all of this stuff and we think this is reasonable and customary based off of blah, 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 some additional bullshit, right? That's just not how it works. But remember, they make money by making you go away and accept the least amount of money. So hit them with this 1-2 combo that I love to do with all of my negotiations. Here's the question. Is there any additional information that I can provide for you so that you can increase your valuation of this case? And then you wait. A lot of times the insurance company is looking for additional documentation like proof of future surgeries or proof of procedure estimates and recommendations, or tax records if you're an entrepreneur or business owner and you want to get paid for your lost wages. Let the insurance company tell you what they need to increase the value of your case, and then provide it for them. I definitely don't recommend giving a recorded statement to the insurance company. Instead, ask them to provide you the information, you study it, and then you will respond in writing when you are good and ready. If you use those 2 questions strategically, you will almost guarantee that the insurance company will provide you a higher offer before you even begin the negotiations. Finally, do not let the insurance companies pay your medical bills. Insurance companies will go behind you and negotiate with all of the doctors that you treated with to get a discount on your medical bills, but they are not entitled to that benefit. So, whenever you're negotiating with an insurance company, make sure that they pay you the entire amount up front. Do not let them handle any medical bills. But CEO lawyer, what if the insurance company says that there's a medical lien and that they are required to pay it off? Aha! That's when you tell the insurance company that you will be wholly responsible for any valid medical liens. Not all medical liens from medical facilities are legitimate, which means that you can negotiate with all of the doctors and get an even steeper discount if you get paid upfront from the insurance company. Remember, the insurance company should not benefit from your detriment, so don't let them pay your medical providers on your behalf. I'm attorney Ali Awad, the CEO lawyer, and those are my 3 tips on how to settle your personal injury case without a lawyer. If you have any questions or you want to know exactly how much your case is worth, feel free to DM me at CEO Lawyer on any social media platform or visit my website at ceolawyer.com.